Okay, let's go on the record on cause number DC 208611, Downing Labs LLC versus WP Pharma Labs Inc. Counsel, make your appearances.
Stephen Clark for the plaintiff, Downing Labs.
Good morning, Your Honor. Josh Sandler and Holly Stubbs for the defendant, WP Pharma Labs Incorporated. Your Honor, a couple of housekeeping.
Mr. Clark, before we get started, is your first name spelled S-H-A-R-I-N? Is it Sharon or Stephen?
No, it's Stephen. I don't know why my wife's name is popping up on the Zoom link, but
Can you spell your name for the court reporter?
Stevenclark.
And then there's a Holly Stubbs here as well. Is that correct?
Yes, Your Honor.
Go ahead, Ms. Stubbs, introduce yourself.
Yes, Your Honor. Holly Stubbs on behalf of WP Pharma.
Okay, we're here on a motion for summary judgment. Do you guys want to go ahead and proceed?
Yes, Your Honor.
Yes, Your Honor. I'm sorry, counsel. I didn't mean to interrupt you. One quick thing, Your Honor, housekeeping wise, certainly we'll defer to however you want to do it. There are a couple of objections to some late filed motions. I think that may have some bearing on how the court wants to dispense with the motion.
I looked at that. I'm going to go ahead and grant the motion to file, grant the motion to strike late filed replies. So let's go ahead and get moving.
Thank you.
Okay. Your Honor, if I may proceed.
You may.
As the plaintiff movement, we are requesting an interlocutory summary judgment from the court on the promissory note that was executed by WP Pharma. In support of that, we are relying on the affidavit of Christopher Downing and my affidavit, which collectively establish that Downing Labs is the holder of the note, that Pharma defaulted under the terms of the note, that there was an acceleration of the balance notice and acceleration of the balance, principal balance due. And through my affidavit and attached exhibit B, which was a letter I sent in June of 2020, we gave the notice, and then again in September, an updated notice and a request for Pharma to assemble the collateral under the security agreement. And so the principal balance due as accelerated is $695,863.62. In addition to that, Mr. Downing's affidavit, as well as mine, which they didn't object to, also indicate that there is accrued interest at the rate of 5% per annum, and we're just over 12 months since they stopped making payments on the note, which was in October of 2019. And then in addition to that, there's a late fee under the terms of the note of 5% as well. So I have those calculations if the court needs them, but it's basically a numerical exercise of taking 5% of the principal balance. So, and then we've asked for our attorney's fees, which we would, submit post-hearing if the interlocutory motion is granted. I don't know if the court wants me to address their argument related to
their argument is that there's an offset, essentially, correct?
Yes, they're arguing that there's an offset under the terms of the note, and our position is that their affidavit is insufficient to raise the material issues of fact related to establishing the affirmative defense of offset. They have submitted a an affidavit from Jason McLaren, who's the president of the company. But and there are three principal offset issues that they're arguing. One is that there was defective equipment. Secondly, that that there was an unpaid tax assessment. And then the third, which is the largest potential offset that they're raising, is that that a number of the prescriptions, this was a compounding pharmacy where they purchased the assets under an asset purchase agreement. And they're claiming that the financial statements were overstated because a lot of the prescriptions were for office use, which they contend was illegal under a consent decree that had been entered into by the Downings before the asset purchase agreement was executed. So, but from our perspective, the deficiency in the affidavit is that it references attached letters, but there's no underlying support to support the factual statements to raise the issue of offset.
And I'm so sorry to interrupt. That issue was the express substance of their reply, which the court has already stricken.
I'm sorry, I didn't get all that.
I couldn't hear you.
Sorry.
Oh, I said that issue, which my friend on the other side was just mentioning regarding offset and evidentiary objections there too, is the express substance of their reply, which the court has stricken. Otherwise, I apologize to interrupt.
It looks like, Mr. Sandler, that you have moved for a continuance on this hearing because you feel like you need more time to conduct discovery on the issue of offset. Is that right?
If I could have about 20 seconds to explain that in further detail, Your Honor.
Sure.
We believe, and we're happy to walk the court through this so they can feel comfortable with it, that there are genuine issues of material fact in the summary judgment record right now that should make the court feel very comfortable in granting summary judgment as a matter of, as denying summary judgment as a matter of law now. We put the notion of a continuance before the court so that the court is aware that, if they were to come back and, for example, put their calculations into the record, right now it's devoid of that. That can happen in a week or 2 weeks' time. We would still be back before the court at that point asking for a continuance because there is information that needs to be obtained.
So you can't have it both ways. So if you want to move for a continuance because you need more discovery for this particular motion, then I'll hear that now and I'll make a ruling. If you don't need it for this particular motion and you feel you have enough evidence, or you don't need discovery, I guess, for this particular motion, but you can't really say, hey, look, if I think I have enough evidence, but if I don't, then I want a continuance. You kind of can't have it both ways. Either we're going to continue this or we're going to hear it based on what the record is right now.
Certainly. Well, I think the defendant is prepared to move forward and ask the court to rule on the summary judgment record as it stands right now.
Okay. Let's go ahead and proceed then.
And Your Honor, if I have a brief presentation to show the court, if I may.
Sure. Let you share screen it.
Thank you, Your Honor.
Are you share screening?
No, not yet. I'm trying to. Let me close it out. Pardon me. Thank you, Your Honor. Can you see that?
I can.
Okay, thank you, Your Honor. We've already, in our response, informed the court that this case is not merely a suit to recover on a promissory note. There's far more involved, and the court is well aware of the fact there are offsets involved. And so, quite frankly, this is not despite what the plaintiffs may want to do here. This is not one of those round peg goes into the round peg slot. This is very much the square peg case. And the reason for that is because the actual motion for summary judgment record discusses the fact that there is a note, but does not talk about the overall document at issue, which is the asset purchase agreement. We'll get into that in a minute. But briefly, Your Honor, WP Pharma, as my colleague on the other side mentioned, we're talking about a compounding pharmacy that is limited to dispensing for home use only. So, Your Honor, just by way of background, what WP Pharma does, it works on functional medicine, anti-aging, weight management, aesthetic dermatology, thyroid, adrenal health, and things like that. As I mentioned to the court a moment ago, and Your Honor, can you hear me okay?
I can. You might want to speak up a little bit, but yeah, I can hear you.
Thank you. I will. There is an asset purchase agreement that was entered into May of 2019, whereby WP Pharma purchased the labs, the Downing labs, for $1.5 million. Now that is a suite of documents, all articulated under the asset purchase agreement. So there's three relevant agreements, Your Honor. Exhibit B, you'll note, is a $710,000 note. That is the basis of this lawsuit. But it's important for the court to understand that all of these were encompassed within the asset purchase agreement. The Downings, which is Ashley and her husband, the Downings, the actual couple, as well as the Downing lab, as articulated in the asset purchase agreement, made three material representations that we want to draw the court to, because these are right now in the summary judgment record genuine issues of material fact. So they represented that and expressly warranted that all tangible assets to be conveyed to WP Pharma are in adequate working condition and repair and are suitable for the purposes for which they're being used, and are of a condition, nature, and quantity reasonably sufficient for the conduct of the business. In sections 3.7 and 3.8 of the asset purchase agreement, Downing Labs represented that they have provided to the court, they have provided to the buyer, WP Pharma, accurate financial information, presented fairly in all material aspects, and that they have no liabilities or obligations that were reflected in the financial information that they disseminated to WP Pharma for purposes of the sale. And then finally, section 3.9 said that they're in compliance with all the legal requirements that they are subject to, which includes requirements under the FDA.
I'm sorry, under the what, Mr.?
The FDA, the Food and Drug Administration. The asset purchase agreement, Your Honor, also contains an indemnification provision, which is a very broad indemnification provision. And it says that seller Christopher and Ashley jointly and severally will indemnify and hold harmless the buyer, which is WP Pharma, and buyer's representatives for and will pay to the indemnified person the amount of any loss, liability, claim, damages, including incidental and consequential damages, expenses, including costs of investigation and defense and reasonable attorney's fees for diminution of value, whether or not involving a third-party claim arising directly or indirectly from or in connection with any breach of any representation or warranty made by the seller or the Downings in this agreement. These are the representations that we are at least aware of now that have been breached. So that's what's in the asset purchase agreement, and here they're agreeing to indemnify. Moreover, the asset purchase agreement states that indemnification obligations may be satisfied by set-off by WP Pharma that are due and payable to the Downings. Now, I mentioned, Your Honor, that the asset purchase agreement also contained the note. The note is what they're suing on, and their motion for summary judgment is on the note, and it doesn't say anything about the asset purchase agreement. So what we're attempting to do is give the court the full knowledge of the contractual obligations between the parties. That note also has a right of offset provision. And it says that if any amounts become due from the Downings to WP Pharma under the terms of the asset purchase agreement, WP Pharma may offset the amount due to the Downings. And if you look specifically under the provision that we copied here from the contract, it says against the unpaid balance of the note. So that's kind of the facts that we're dealing with. So we have a somewhat unusual circumstance whereby if there are material representations.
So why don't you go through kind of the evidence that shows that there's amounts due? Okay, you just switched it.
Oh yeah, I'm happy to show the court that, Your Honor. So if the court
I was still working on my question, Mr. Sandler. You're jumping ahead a little bit. I apologize.
I'm so sorry.
The question I have is, what evidence is there that there's amounts due from the Downings to WP Pharma under the terms of the purchase agreement?
Thank you, Your Honor. And I'm so sorry for interrupting you.
That's okay.
The declaration of Jason McLaurin, which will appear in our response in our appendix 1 through 3, shows that he sent 2 letters to Mr. Clark, who's counsel for the plaintiffs, indicating these indemnification, or indicating these offsets. They gave notice of these express breaches of these obligations by the Downings, and the Downings did nothing on them. And so we've established that those have not been objected to in terms of the evidence that is in front of the court. So those have also been proven up under the Texas Rules of Evidence. And in those letters, again, Mr. McLaurin, who is an officer of WP Pharma, provides notice to the Downings as to these offset issues, and specifically these breaches right here, Your Honor, that I've kind of gone through. And so they have notice of these breaches, and the fact of the matter is that you cannot seek summary judgment at this time because we have specific offset provisions that have not been accounted for that must be. And so we talked earlier about whether or not we need a continuance to establish those offset facts. That's going to come in discovery, but there is expressly a genuine issue of material fact now that precludes summary judgment on this note as a matter of law, because these are the fact issues that we're putting before the courts. So there's not an entitlement to judgment as a matter of law. And here are those fact issues. I don't want to take up too much more of the court's time, and I apologize again for interrupting earlier. I didn't hear you say. We go through in these letters that the court will see that are in the summary judgment record. We tell them about equipment that's broken, not maintained, and unsuitable. And we tell them that Downing Labs failed to pay their taxes. We also tell them that the majority of the revenue is from the legal office use, which is in violation of federal law. So we are now, and this is again in the letters that have been proven up, and they're in the summary judgment record, that show how the Downings have actually breached the express warranties in the asset purchase agreement, and thus they're entitled to offset pursuant to the express wording of the note. When we informed the Downings that we were seeking indemnification, the Downings refused to honor this agreement. And instead, what they did was they filed this lawsuit. This lawsuit, as the court knows, has not been on file very long. I think it was first filed in June. They filed this suit and they omitted the express promises and provisions of the asset purchase agreement. So the court well knows the issues on suit on a note, the elements. So we have kind of 2 prongs we want to bring to the court's attention. One is the genuine issue of material facts that we are telling the court. The other is as a matter of law. And my colleague can also get into the evidentiary objection we've made on this issue, Your Honor. But there are no specific details on the offset based on personal knowledge. Let's see. The fact that the specific details about offsets based on personal knowledge raises a genuine issue of material fact. We've established these material facts here, but the bigger issue, or the equally big issue, is the fact that their damages, which they're seeking summary judgment on, is ambiguous in the sense that they have to give specific details about offsets based on personal knowledge, and they haven't done that. The fact is that plaintiff's counsel told the court at the beginning of this hearing that they have the calculations if the court wants to see them. That is not what you have to do in order to establish an entitlement to a judgment as a matter of law. You have to be able to basically show your work. Right now, there is a principle they are saying they are due and owing, plus some other things like 5% interest, 5% penalties, and attorney's fees. None of those figures are in any evidence. And so as a matter of law, their motion for summary judgment is deficient because they haven't shown those their entitlement to those damages, or in fact, what those damages are. And at this point, Your Honor, to talk more about those evidentiary issues, if it please the court, I'd like to ask my colleague to further expand on that point.
Let me hear from the other side first. Mr. Clark, you can speak if you'd like.
Okay. Well, let me try to address what I think is the problem as it relates. First, let me address the adequacy of the motion itself. The FFP case that they cite indicates that a statement of the principal balance due plus the terms of accrued interest and late charges is sufficient in the general case. And so we have that statement, and we have the reference to the note itself, which provides the specific terms which were referenced in the Downing affidavit. So we think from that perspective that we've established the necessary elements. The ambiguity in the FFP case was because there were multiple notes and guarantees. We're not dealing with that situation here. The argument seems to be that because we didn't put the APA agreement into evidence, that there somehow it's defective. But as counsel notes, the note itself expressly references a right to offset. But when we get to the offset issue, it's their burden to come forward with evidence to raise material issues of fact. And the way they attempt to do that is through the McLaren declaration attaching two letters that he wrote to me and to my clients, which basically reference the three areas of offset that they're claiming. However, there's nothing in the McLaren affidavit to really establish his competency to testify to any of those three things. For example, there's not a discussion about the defective equipment and that he was personally involved in that investigation. There's no reference. He says that the financial statements are overstated because of this claimed illegal office use prescriptions, but the financial statements aren't attached or referenced, and the representations in the financial statements aren't referenced in the declaration. And then finally, with regard to establishing a violation of law, there's simply no evidence presented whatsoever to show that these, in fact, were violations of federal law. None of those prescriptions are identified or referenced. So from our perspective, it's their burden. We're not asking for a final judgment at this point. We're asking the court for an interlocutory summary judgment under the terms of the note, which we have established. We've established ownership, default, the amount due, and it's their burden to establish the offset. So The only other thing from a housekeeping standpoint is we did file objections to their late filed answer and counterclaim. And we think that those shouldn't be considered, particularly the one that was filed Friday, because those were filed without leave of court. And if you look at Rule 63, it says that anything within 7 days requires leave of court. And those amended pleadings and counterclaim were both filed within 7 days without leave of court. So anyway, to kind of sum up, we think we've established our right to summary judgment as a matter of law under the note for interlocutory summary judgment. They want to develop their counterclaim related to offset, and that's fine. But in terms of, they're going to have that opportunity to do it. But in terms of where they are now, they haven't raised adequately through the declaration and the attached letters, material issues of fact to defeat our right to the interlocutory summary judgment.
Brief response to that, Your Honor.
Ms. Stubbs, did you want to say anything?
You're muted, Ms. Stubbs.
I'm sorry, Your Honor, what were you asking?
You were supposed to say something earlier and I kind of cut you off, so I wanted to give you a chance.
Oh, that's all right. I just wanted to, we have an objection on plaintiff's evidence on paragraph 5 of their Downing affidavit. And similarly to what my colleague, Mr. Sandler, has been saying, is they just make a conclusory statement and they don't provide any calculations to support the fact. And quickly, what they don't provide is they do not provide a statement that is in compliance with the terms of the note and the asset purchase agreement on its face. The note and the asset purchase agreement include the requirement to allow WP Pharma to offset any damages. And they don't include whatsoever in their evidence any calculation showing that they have considered the contractual provisions of offset.
So, Mr. Chandler, let me ask you, or Sandler, I'm sorry, Mr. Sandler, let me ask you this. So, why don't we just grant the summary judgment and then you guys can argue your offset argument at trial? Why wouldn't that be appropriate?
Because first of all, we've established a genuine issue of material fact that that amount is not due and owing. So as a matter of law, the court cannot enter summary judgment on that issue because it's disputed.
Couldn't we at least decide on the issue of breach? Maybe not as to damages?
I don't think so, Your Honor. I'm sorry, Ms. Stubbs, go ahead.
Oh, I was going to say, no, we can't establish it on the issue of breach because we haven't breached the agreement because we are not, there's no balance due and owing. So because there's no balance due and owing, because we are due offsets, there is no breach.
And that's expressly referenced in the asset purchase agreement, Your Honor. And the argument that plaintiff's counsel was making regarding the evidence before the court, particularly in the McLaurin declaration, these are all points that they make in their late filed reply that the court has said they would not consider. So there are two reasons here that the court cannot enter summary judgment, regardless of whether they're asking for summary judgment on the breach or on the full summary judgment. And I think that the plaintiff's pleadings have gone a little bit both ways. So we briefed it as such in terms of going both ways, because here we were at the beginning talking about calculations of damages, and then we kind of pivoted, or plaintiff's counsel kind of pivoted back to, well, we're actually just seeking summary judgment on breach. So there are genuine issues of material fact which preclude breach. And those are the offset provisions and the indemnity provisions, which are on the record. And that's a fact issue. If the plaintiff is moving for a summary judgment on the damages, which in various of his pleadings He does ask for, and I would say his order to the court also asks for that. So I'd say that this notion of an interlocutory summary judgment is either waived or and certainly ambiguous. Then they are not showing an entitlement to judgment as a matter of law, because they haven't given the court a calculation that it could enter in that event.
All right. Did you want to say anything else, Mr. Clark?
Just on the last point, Your Honor, I think the court has hit the right point, which is the issue really before the court is whether there has been a breach under the terms of the note. And we clearly established that breach. So I think, interlocutory summary judgment on the breach is appropriate. Their burden is to establish their right of offset. Just saying that an offset right exists is not adequate. If they are going to defeat summary judgment entirely, it seems to me that they have to affirmatively show material issues of fact under the rules. And the question really here is whether the McLaren affidavit declaration and the attached letters, which they're trying to prove up as business records, are adequate enough to create the material issues of fact. We don't believe so, and that's something the court can determine on the face of the record. So we would say that, an interlocutory summary judgment as to breach and as to the principal amount due and under the terms of the note, which is before the court, is appropriate.
All right, well, great argument by both sides. Excellent PowerPoint, as always, by Lynn Pinker, Mr. Sandler, and Ms. Stubbs. I'm going to go ahead and deny the summary judgment. And anything else we need to chat about today?
Your Honor, I want to keep thank you. I want to keep keep out of your hair, but we do have a setting trial-wise for December. I've spoken with my colleague on the other side, given what we talked about before the court today.
A setting for what?
Trial setting, Your Honor. It's non-jury.
Okay.
We've also
it's non-jury or jury?
Well, it's non-jury now. We paid our jury fee, so I believe it will change to a jury setting.
Okay.
I think both Mr. Clark and I would like the opportunity to engage in discovery, et cetera. And so if you would like us to call the court clerk and talk about dates for a setting sometime next year.
I can reset you now if you want to, or you can file a continuance, or if you're agreed to, I'll reset it. If you're not agreed to, obviously you have to have a motion and everything. But if there's no way I can try a jury trial like this in December, so
right.
I'd be glad to move it. But if there's a disagreement, then you'll have to go through the whole process.
No, there isn't a disagreement in moving the trial date, Your Honor. The only issue would be, what we would be looking at as a reset date.
So, this is a constantly changing situation. I'm sure you guys have all heard that we've adopted a jury plan that allows us to do hybrid trials. We just, I think, adopted, this is still in the works, but I think we're about to, if we haven't already, adopted an amendment to that says that as long as we're in status red for COVID-19 in Dallas County, then we're not going forward with any jury trials. So we have a plan, but we can't go forward with it right now. There has been some discussions, and I'm maybe doing a small car wreck jury trial that is entirely remote on November 17th. That's a little bit up in the air. So all that being said, I don't know what the status is going to be. I don't think we're going to be having any trials in December, and definitely not one like this. So I'm perfectly happy to move it. The question becomes kind of when, as you can imagine, we haven't had jury trials for now 8 months, or almost 8 months. We're going to be very backlogged for quite some time. If you can do it as a non-jury, I can get you in much, much more quickly because we are churning those out like crazy. So we could get you to trial pretty quickly if you're willing to do a non-jury. But if you're insisting on a jury, we can set you during the summer, but the likelihood is you won't get reached for a couple of years.
That sounds discouraging.
Sorry.
Your Honor, to be frank with the court, in order to not have a jury trial, I simply would just need to get permission from my client, which I'm not prepared to discuss now.
Sure, I understand.
I think my marching orders are to either get a setting from you in June or sometime in summer of 2021 with the understanding that we may not be reached. That will give us something that we can base some dates off of a scheduling order for, which I would like to do. More importantly, for me, just to have a date so that we can start getting that rolling. So I think if it pleases the court, that's what I would still ask the court to do, just so we can start working toward the scheduling. Which also reminds me, Your Honor, we have submitted to you a checklist order for you on the summary judgment.
I already filled it out.
Okay, thank you.
So if you want a jury trial in June, there's, again, very small likelihood you'd actually get reached, but June 1st, June 8th, or June 22nd.
I'll certainly defer to my colleague.
Just a second, Your Honor. I've had a number of cases reset, as you can imagine. I could do the 1st or the 8th.
June 1st, then, Your Honor, if that's okay.
Rhonda, go ahead and say, do you have a mediator picked out already?
We have mediated already, in fact, Your Honor.
Okay. Okay, great. So we'll reset this. Rhonda, go ahead and reset this to June 1st and send out a new trial notice. And anything else we need to chat about, guys?
Not from defendant.
No, that's it, Your Honor.
Okay. Rhonda, can you go check with Rhonda, Nancy, and see if she just got it. Never mind. So we'll send you a new trial setting for June 1st. And if you decide you can do a bench trial, let us know and we'll set you on a non-jury week. And we've been going through those very, very quickly. So it works well on Zoom, I think. So if you're willing to do that, let us know. But if not, you have a right to a jury trial. We'll just try to put you in when we can.
Thank you, Your Honor.
Thank you, Your Honor.
Excused.
Thank you.
All right. Thank you, guys. You guys be safe.
Thank you.
All
Nice
right,
to see
you too.
Thank you.
Bye.
All right. The intern, stay on for a second.
You want me to go ahead and leave, Judge?
Yeah, I'm just checking what time we're next. I think our next hearing's at 1:30, but I'm not sure.
It is motion from Paul Fisher.
Oh, yeah.
Fisher versus Fisher. It's a closed case. So.
Yeah, it should be reopened. So, Rhonda, this case, I think I emailed you and Rose about this. This case should be open, that Fisher case. It was closed for a while because it went to family court. Court of Appeals sent it back to me, part of it back to me. So it needs to be reopened. And I think there is a trial setting on it. But this 1:30 hearing is with some really, really good lawyers. Yeah, 6:29 is the trial setting. So, but this needs to be reopened. This is have you guys seen any hearings on this case already? I think some of you have. Are you guys there? Tara, have you seen some hearings on this already?
What's the case name?
Fisher v. Fisher. It's the case that is a family law case, and the part that came to me involved a company that was owned by the family. And I'd always understood that the family courts could hear those types of cases, but the Court of Appeals just established that if it's a purely civil matter, then it goes to my court. And if it's a purely family court matter, it has to arise out of the family code for them to be able to keep it, which had never been my understanding, but they've made it clear that's the way it works. So we had to split the case in half. Everything involving the family arising under the family code had to stay in the family court, and then everything that's involving purely civil issues like breach of fiduciary duty and all that stuff. Oh, I'm still on Zoom. Sorry.